We have a case. This is justice served. Today's story is called My Wife Sold My Private Collection. The judge subpoenaed the buyer in court. A man comes home to find that his wife of 8 years has quietly sold off his most prized possessions to a stranger. She thought she was being clever. She thought she could explain it away. But she signed something she should never have signed, and by the time she realized what she had done, the trap had already closed around her. I started collecting aviation manuscripts when I was 19. Wartime flight logs, original navigation charts, handwritten notes from pilots who flew missions most people have never heard of. It took me over a decade to build that collection, piece by piece, auction by auction. Some items I tracked down through private sellers across 3 countries. It was not just a hobby, it was something I had built with my own hands and my own money long before I even met Nora. Nora and I got married 8 years ago. She never cared about the collection. That was fine. Not everyone has to care about the same things, but she knew what that room meant to me. She knew I spent years putting it together, and she knew I kept it in the second study, locked, climate-controlled, insured under a separate policy she never asked about. That last part is important. She never asked about it, and that is what saved me. It was a Thursday in October when I came home from a work trip and something felt wrong. Not dramatically wrong, not like the house had been ransacked, just wrong. The air in the hallway near the second study felt different. I walked in and the room was empty, shelves cleared, cases gone. The humidity monitor was still running on the wall, blinking in an empty room like nothing had changed. I stood there for maybe 30 seconds, just staring at bare wood where my collection had been. I found Nora in the kitchen. She was chopping vegetables like it was a normal Thursday. I asked her where the manuscripts were. She didn't even look up. She said she sold them, just like that. 2 words, she sold them. I said, "You sold my collection?" And she finally looked at me with this expression that I can only describe as mildly annoyed. Like I was bothering her with a question she had already answered. She said they were taking up space. She found a buyer, and she deposited the money into our joint account, $340,000. She said it like she had done me a favor. I asked her who the buyer was. She said some dealer named Ronan Ashford. I asked how she even found him. She said Caspian knew him. Caspian, her brother, the one who always needed money. The one who had asked me for a loan twice in the last year, and I had said no both times. If you're watching this and something about that feels off, drop a comment and subscribe to the channel. It helps a lot. And honestly, when you see where this goes, you're going to want to talk about it. Every comment reminds me there's a real human behind this channel, and that keeps me going. I didn't yell. I didn't throw anything. I went back to the empty study and I sat on the floor. Not because I was devastated, because I was thinking. Something about the way Nora told me did not sound like a woman who had made a mistake. It sounded like a woman who had executed a plan and was now waiting for me to get over it. Here is what she did not know. The collection in that room was not mine, not legally. I was the custodian. Every single piece in that room was on loan from the Whitfield Aviation Trust, a private historical preservation group based in Virginia. I had signed a custodial agreement 5 years ago. The trust owned the manuscripts. I maintained them, cataloged them, and displayed them in controlled conditions. I could not sell them. I could not transfer them. I could not let anyone else take possession of them without written authorization from the trust. Nora never read that agreement. She never asked to. And when she sold those manuscripts to Ronan Ashford, she signed a bill of sale as the seller. Her name, her signature, not mine. I did not sleep that night, not because I was angry, because I was calculating. I spent 3 hours on my laptop with the custodial agreement open on one side and a notepad on the other. The agreement was clear. Unauthorized transfer of trust property constituted a separate civil offense, and because the trust was a registered nonprofit, it also carried potential criminal liability under state law. The person who transferred the property was liable, not the custodian, the transferor. Nora had signed herself into that role the moment she put her name on that bill of sale. The next morning I called the trust director, a man named Gerald Fisk. I told him what happened. He was quiet for a long time. Then he said, "She signed the bill of sale?" I said, "Yes." He said, "Not you?" I said, "No." He said, "Don't touch anything. Don't confront her. We'll handle this from here." I hired an attorney that same afternoon, not a divorce attorney, a civil litigation attorney named Diane Pallister. I laid out the situation. She read the custodial agreement. She read the trust's bylaws. Then she looked at me and said something I will never forget. She said, "Your wife didn't steal from you. She stole from a trust," and she left a paper trail doing it. Over the next 2 weeks, I did something that probably sounds cold. I acted normal. I ate dinner with Nora. I slept in the same bed. I asked her about her day. I did not mention the collection. I did not mention Ashford. I did not mention Caspian. And the entire time, Diane and the trust's legal team were building a case. Nora thought I was processing it. She even said that to her sister on the phone one night while I was in the next room. She said, "He's quiet, but he'll come around. He always does." That sentence told me everything. She did not think she had done something wrong. She thought she had done something I would eventually accept. Let me pause here for a second, because I want you to understand what kind of person does this. Nora did not sell my collection because we were broke. We were not broke. She did not sell it because she needed the money for something urgent. She split the money with Caspian. Half went into our joint account, half went to her brother. She sold it because she wanted to, because she decided my things were hers to sell, because 8 years of marriage, in her mind, meant she had that right. And the fact that she never once asked me about the legal ownership of those manuscripts tells you exactly how much respect she had for the boundaries of what was mine. Now here is where the story takes a turn that even I did not see coming at first. Diane filed a motion to subpoena Ronan Ashford, not to sue him, to bring him in as a material witness. Ashford was a licensed dealer. He had bought stolen property, but he had also received a signed bill of sale from the person who presented herself as the owner. He had a paper trail too, and that paper trail did not protect Nora. It incriminated her. Ashford's attorney contacted Diane before the hearing. He wanted to cooperate. He wanted to return the manuscripts. He wanted out. Because once he found out the collection was trust property, he understood that keeping it made him liable too. He turned over the bill of sale voluntarily and agreed to testify. Nora found out about the subpoena 3 days before the hearing. She came home from work and her entire demeanor had changed. The confident woman who had told me she sold my collection like she was telling me she returned a library book was gone. In her place was someone pale and quiet and suddenly very interested in what I was doing on my laptop. She sat across from me at the dinner table and said, "Sutton, what is going on?" I said, "What do you mean?" She said, "I got a call from Caspian. He said a lawyer contacted him. He said something about a trust." I looked at her and I said, "The collection wasn't mine, Nora." She blinked. I said, "It belonged to a historical trust. I was the custodian. You didn't sell my property. You sold theirs." The silence that followed was the loudest silence I have ever heard in my life. She opened her mouth, closed it, opened it again. Then she said, "Why didn't you tell me that?" And I said, "You never asked." That is not a dramatic line. It is not a revenge speech. It is just the truth. She never asked. She looked at a room full of things that mattered to me, and she never once asked who they belonged to, what the terms were, or whether she had any right to touch them. She saw value and she took it. The hearing was not a trial. It was a civil proceeding where Ashford was compelled to produce the bill of sale and testify about the transaction. Nora had her own attorney by then, a criminal defense lawyer Caspian had found. Her attorney tried to argue that Nora had a reasonable belief she had spousal authority to sell marital property. Diane dismantled that argument in about 4 minutes. She produced the custodial agreement. She showed that the collection was held under a separate trust designation that appeared on our homeowner's insurance policy. She pointed out that Nora had signed the bill of sale as the sole seller, not as a co-owner, not as a spouse acting jointly, just as the seller, her name alone. If this is hitting you the way it hit me when I realized what was happening, you need to subscribe and leave a comment right now. Tell me this is a real human behind this channel, because this is the kind of story that reminds me why I do this. The system actually worked for once. Ashford testified for about 15 minutes. He was calm, professional, and clearly just wanted to hand the manuscripts back and go home. He confirmed that Nora had contacted him through Caspian. He confirmed that she had represented herself as the owner. He confirmed that she had signed the bill of sale. He handed over the original document. The judge examined it, held it up, and asked Nora's attorney if his client disputed the signature. Nora's attorney said no. She did not dispute that she signed it. She could not. It was her handwriting, her name, her legal acknowledgement that she was the owner selling the property. In one document, she had established both the act and the intent. The trust filed a civil lawsuit against Nora and Caspian the following week. The claim was for the full appraised value of the collection, which was not $340,000. That was what Ashford paid. The appraised value was over $1.2 million. The trust's attorney argued that the sale price was evidence of knowing undervaluation, which supported a claim for punitive damages. Nora's half of the $340,000 was frozen by court order. Caspian's half was already gone. He had spent most of it within weeks of the sale. The trust went after both of them. Caspian was charged with acting as an unlicensed broker in the sale of property he knew or should have known was not his to broker. Nora was named as the primary defendant in the civil suit. Her defense attorney tried to negotiate a settlement. The trust refused. They wanted a judgment. They wanted it on record. I want to be honest about something here. During the weeks when all of this was unfolding, people who knew about it kept asking me if I felt bad, if I felt like I had set Nora up, if I should have just told her the truth about the collection before it went this far. And I thought about that a lot. I really did. But here is what I kept coming back to. Nora did not accidentally sell my collection. She contacted a dealer through her brother. She transported the items. She negotiated the price. She signed a legal document. She deposited the money. She split it with her brother. And she did all of that without saying a single word to me until I came home and found an empty room. That is not a mistake. That is a decision. And decisions have consequences. The civil judgment came down in March. Nora was ordered to pay the trust $920,000 in damages and legal fees. Caspian was ordered to pay $310,000. Between them, they owed over $1.2 million for a collection they had sold for $340,000. Nora's attorney filed for bankruptcy on her behalf. The trust's attorney filed an objection, arguing that the debt arose from intentional misconduct and should not be dischargeable. The bankruptcy court agreed. The debt was not dischargeable. Nora owed the money. There was no way out. I filed for divorce the same week the judgment was finalized. Nora did not contest it. There was nothing left to contest. The joint account was empty. The house was going to have to be sold to cover part of the judgment. Her attorney had quit. Her brother wasn't speaking to her. And the trust had their manuscripts back, every single piece, returned by Ashford in the same condition they left. I went to the trust's facility in Virginia to help recatalog the collection after it was returned. Gerald Fisk met me at the door. He shook my hand and said the collection was in good shape. Ashford had actually stored it properly. I asked Gerald if I could continue as custodian. He said yes. He said the trust board had reviewed my file and found no fault in my conduct. I had followed every protocol. I had reported the theft immediately. I had cooperated fully. The only person who had broken the agreement was the one who had never read it. I drove home that night with an empty passenger seat and a house that was about to go on the market. 8 years of marriage reduced to a for sale sign and a judgment that would follow Nora for the rest of her life. I did not feel victorious. I did not feel like I had won. I felt like I had watched someone I loved destroy herself over money she didn't even need, and the only thing I had done was step out of the way. But I will tell you this. When I walked back into that second study after the collection was returned, and I saw those manuscripts back on the shelves, the flight logs in their cases, the navigation charts framed where they belonged, I stood there for a long time. And I thought about what Nora said when I asked her why she did it. She said, they were just sitting there, like they were nothing, like the years I spent finding them meant nothing, like the trust that preserved them meant nothing, like I meant nothing. They were never just sitting there, Nora. They were exactly where they were supposed to be, and so was I. The irony of this entire case is that Nora thought she was selling her husband's hobby. She thought it was just stuff. She had no idea she was walking into a legal framework that was built specifically to protect historical property from exactly what she did. She signed her name on a document that said she was the owner. She made herself the liable party, and she did it all without ever once asking the simplest question in the world: whose collection is this really? One question, that is all it would have taken, but she didn't ask. Because asking would have meant admitting she didn't already know, and Nora would rather sign away someone else's property than admit she didn't know something. So here is my question for you. If you were in Sutton's position and you discovered your spouse had sold something that wasn't even yours, something that could legally destroy them, would you warn them first, or would you let the consequences find them on their own? Think about that and tell me in the comments.